We continue to convey historical texts. The subject of this content is Magna Carta, which is considered the first constitutional text, although it is not the oldest known law text. Magna Carta or Magna Carta Libertatum is an English document signed in 1215. With this document, the King of England, by being required to relinquish some of his powers, to act in accordance with the law, and to accept that the law is superior to his wishes and desires, the king's powers were restricted for the first time in the history of England, and he granted some rights to the feudal lords. Magna Carta is one of the most important steps in the historical process until we reached today's constitutional order. The document, which contained provisions in the text that theoretically restricted the king's powers, Pope III. It was signed between Innocentius, King John, and his barons to decide the issue of the king's powers. According to Article 61, a reference was made to feudal laws, and it was stated that 25 barons could oppose the king's ruling. None of the parties remained true to their promises in the document, and Pope III. Innocentius' annulment of the document caused the First Barons' War. The events that took place in the preparation of the document date back to the Normans' conquest of England. The aim of the English kings is to eliminate their feudal lords by seizing power after the conquest. All activities carried out in this field began to disturb the barons in the country. These increasing disturbances led to rebellions in the future. The conflict between the king and the barons, which had been going on for 150 years, became unmanageable with the initiatives of King John. Thereupon, the king used all his power against the feudal lords. This behavior angered the feudal lords. In the future, the barons, who saw the defeat of King John in the war with the French, 1214, as an opportunity, took action to take back their privileges, lands, castles, and other similar rights in the country. The barons gathered together and decided to present their wishes to the king in the form of a declaration. They agreed among themselves that they would fight if the king refused their demands. After this decision, the barons met with the king in 1215. At the end of the meeting, the king said that he would answer their requests in the future and did not keep his word. Thereupon the barons rebelled against the king. The barons, who captured the important places and cities of England, forced the king to agree. With the Magna Carta signed in June 1215, the king agreed to restrict his sovereignty on behalf of landowners called barons. In this way, the king's indifferent suzerainty was abolished and the mutual duties of the king and the feudal lords were determined. With the promulgation of the edict, the feudal lords gained great privileges and the concept of feudalism was placed on a solid ground. The people, however, remained serfs and could not escape the situation where the feudal lords bought and sold them along with the land. Magna Carta, which establishes a balance between the dominant powers in society rather than determining the freedoms of citizens, limits the unlimited powers of the king on behalf of the feudal lords and clergy. Article 39 of Magna Carta is one of the most important statements in the edict. This article is considered one of the cornerstones of today's legal system. No free person shall be arrested, imprisoned, deprived of property, outlawed, exiled, or in any way injured, unless lawfully tried and convicted by his peers in accordance with the laws of the land. At that time, it was widely believed that the authority of the king, who had absolute power, was a duty directly given to him by God. With Magna Carta, this view was destroyed, and a parliament consisting of lords began to rule together with the king. This process also led to the decline of the power of the Church. If we look at the articles of Magna Carta. 1. In the first place we have granted to God, and by this our present charter confirmed for us and our heirs forever, that the English Church shall be free, and shall have her rights entire, and her liberties inviolate, and we will that it be thus observed, which is apparent from this, that the freedom of elections, which is reckoned most important and very essential to the English Church, we, of our pure and unconstrained will, did grant, and did by our charter confirm, and did obtain the ratification of the same from our Lord, Pope Innocent III, before the quarrel arose between us and our barons, and this we will observe, and our will is that it be observed in good faith by our heirs forever. We have also granted to all freemen of our kingdom, for us and our heirs forever, all the underwritten liberties, to be had and held by them and their heirs, of us and our heirs forever. 2. If any of our earls or barons, or others holding of us in chief by military service shall have died, and at the time of his death his heir shall be of full age and owe relief, he shall have his inheritance on payment of the ancient relief, namely the heir or heirs of an earl, £100 for a whole earl's barony, the heir or heirs of a baron, £100 for a whole barony, the heir or heirs of a knight, 100 shillings at most for a whole knight's fee, and whoever owes less let him give less, according to the ancient custom of fiefs. 3. If, however, the heir of any of the aforesaid has been under age and in wardship, let him have his inheritance without relief and without fine when he comes of age. 4. The guardian of the land of an heir who is thus under age, shall take from the land of the heir nothing but reasonably produce, reasonable customs, and reasonable services, and that without destruction or waste of men or goods, and if we have committed the wardship of the lands of any such minor to the sheriff, or to any other who is responsible to us for its issues, and he has made destruction or waste of what he holds in wardship, we will take of him amends, and the land shall be committed to 2 lawful and discreet men of that fee, who shall be responsible for the issues to us or to him to whom we shall assign them, and if we have given or sold the wardship of any such land to anyone and he has therein made destruction or waste, he shall lose that wardship, and it shall be transferred to 2 lawful and discreet men of that fief, who shall be responsible to us in like manner as foresaid. 5. The guardian, moreover, so long as he has the wardship of the land, shall keep up the houses, parks, fish ponds, stanks, mills, and other things pertaining to the land, out of the issues of the same land, and he shall restore to the heir, when he has come to full age, all his land, stocked with ploughs and wainage, according as the season of husbandry shall require, and the issues of the land can reasonably bear. 6. Heirs shall be married without disparagement, yet so that before the marriage takes place the nearest in blood to that heir shall have notice. 7. A widow, after the death of her husband, shall forthwith and without difficulty have her marriage portion and inheritance, nor shall she give anything for her dower, or for her marriage portion, or for the inheritance which her husband and she held on the day of the death of that husband, and she may remain in the house of her husband for 40 days after his death, within which time her dower shall be assigned to her. 8. No widow shall be compelled to marry, so long as she prefers to live without a husband, provided always that she gives security not to marry without our consent, if she holds of us, or without the consent of the lord of whom she holds, if she holds of another. 9. Neither we nor our bailiffs shall seize any land or rent for any debt, so long as the chattels of the debtor are sufficient to repay the debt, nor shall the sureties of the debtor be distrained so long as the principal debtor is able to satisfy the debt, and if the principal debtor shall fail to pay the debt, having nothing wherewith to pay it, then the sureties shall answer for the debt, and let them have the lands and rents of the debtor, if they desire them, until they are indemnified for the debt which they have paid for him, unless the principal debtor can show proof that he is discharged thereof as against the said sureties. 10. If one who has borrowed from the Jews any sum, great or small, die before that loan can be repaid, the debt shall not bear interest while the heir is under age, of whomsoever he may hold, and if the debt fall into our hands, we will not take anything except the principal sum contained in the bond. 11. And if any one die indebted to the Jews, his wife shall have her dower and pay nothing of that debt, and if any children of the deceased are left under age, necessaries shall be provided for them in keeping with the holding of the deceased, and out of the residue the debt shall be paid, reserving, however, service due to feudal lords, in like manner let it be done touching debts due to others than Jews. 12. No scutage nor aid shall be imposed on our kingdom, unless by common counsel of our kingdom, except for ransoming our person, for making our eldest son a knight, and for once marrying our eldest daughter, and for these there shall not be levied more than a reasonable aid. In like manner it shall be done concerning aids from the city of London. 13. And the city of London shall have all its ancient liberties and free customs, as well by land as by water. Furthermore, we decree and grant that all other cities, boroughs, towns, and ports shall have all their liberties and free customs. 14. And for obtaining the common counsel of the kingdom anent the assessing of an aid, except in the 3 cases aforesaid, or of a scutage, we will cause to be summoned the archbishops, bishops, abbots, earls, and greater barons, severally by our letters, and we will moreover cause to be summoned generally, through our sheriffs and bailiffs, all others who hold of us in chief, for a fixed date, namely, after the expiry of at least 40 days, and at a fixed place, and in all letters of such summons we will specify the reason of the summons. And when the summons has thus been made, the business shall proceed on the day appointed, according to the counsel of such as are present, although not all who were summoned have come. 15. We will not for the future grant to any one license to take an aid from his own free tenants, except to ransom his body, to make his eldest son a knight, and once to marry his eldest daughter, and on each of these occasions there shall be levied only a reasonable aid. 16. No one shall be disturaned for performance of greater service for a knight's fee, or for any other free tenement, than is due therefrom. 17. Common pleas shall not follow our court, but shall be held in some fixed place. 18. Inquests of novel disseisin, of mort d'ancestor, and of darrain presentment, shall not be held elsewhere than in their own county courts, and that in manner following: we, or, if we should be out of the realm, our chief justiciar, will send 2 justiciars through every county 4 times a year, who shall, along with 4 knights of the county chosen by the county, hold the said assize in the county court, on the day and in the place of meeting of that court. 19. And if any of the said assizes cannot be taken on the day of the county court, let there remain of the knights and freeholders, who were present at the county court on that day, as many as may be required for the efficient making of judgments, according as the business be more or less. 20. A freeman shall not be amerced for a slight offence, except in accordance with the degree of the offence, and for a grave offence he shall be amerced in accordance with the gravity of the offence, yet saving always his contenement, and a merchant in the same way, saving his merchandise, and a villain shall be amerced in the same way, saving his wainage. If they have fallen into our mercy, and none of the aforesaid amercements shall be imped except by the oath of honest men of the neighborhood. 21. Earls and barons shall not be amerced except through their peers, and only in accordance with the degree of the offence. 22. A clerk shall not be amerced in respect of his lay holding except after the manner of the others aforesaid. Further, he shall not be amerced in accordance with the extent of his ecclesiastical benefice. 23. No village or individual shall be compelled to make bridges at river banks, except those who from of old were legally bound to do so. 24. No sheriff, constable, coroners, or others of our bailiffs, shall hold pleas of our crown. 25. All counties, hundreds, wapentakes, and trythings, except our deems neminers, shall remain at old rents, and without any additional payment. 26. If any one holding of us a lay fief shall die, and our sheriff or bailiff shall exhibit our letters patent of summons for a debt which the deceased owed to us, it shall be lawful for our sheriff or bailiff to attach and catalogue chattels of the deceased, found upon the lay fief, to the value of that debt, at the sight of lawworthy men, provided always that nothing whatever be thence removed until the debt which is evident shall be fully paid to us, and the residue shall be left to the executors to fulfill the will of the deceased, and if there be nothing due from him to us, all the chattels shall go to the deceased, saving to his wife and children their reasonable shares. 27. If any freeman shall die intestate, his chattels shall be distributed by the hands of his nearest kinsfolk and friends, under supervision of the church, saving to every one the debts which the deceased owed to him. 28. No constable or other bailiff of ours shall take corn or other provisions from any one without immediately tendering money therefor, unless he can have postponement thereof by permission of the seller. 29. No constable shall compel any knight to give money in lieu of castle guard, when he is willing to perform it in his own person, or, if he cannot do it from any reasonable cause, then by another responsible man. Further, if we have led or sent him upon military service, he shall be relieved from guard in proportion to the time during which he has been on service because of us. 30. No sheriff or bailiff of ours, or other person, shall take the horses or carts of any freeman for transport duty, against the will of the said freeman. 31. Neither we nor our bailiffs shall take, for our castles or for any other work of ours, wood which is not ours, against the will of the owner of that wood. 32. We will not retain beyond 1 year and 1 day, the lands of those who have been convicted of felony, and the lands shall thereafter be handed over to the lords of the fiefs. 33. All kittles for the future shall be removed altogether from Thames and Medway, and throughout all England, except upon the seashore. 34. The writ which is called precept shall not for the future be issued to any one, regarding any tenement whereby a freeman may lose his skirt. 35. Let there be 1 measure of wine throughout our whole realm, and 1 measure of ale, and 1 measure of corn, to wit, the London quarter, and 1 width of cloth, whether dyed, or russet, or halberget, to wit, 2 ells within the selvages, of weights also let it be as of measures. 36. Nothing in future shall be given or taken for a writ of inquisition of life or limbs, but freely it shall be granted, and never denied. 37. If any one holds of us by fee farm, by sockage, or by burgage, and holds also land of another lord by knight's service, we will not, by reason of that fee farm, sockage, or burgage, have the wardship of the heir, or of such land of his as is of the fief of that other, nor shall we have wardship of that fee farm, sockage, or burgage, unless such fee farm owes knight's service. We will not by reason of any small sargenty which any one may hold of us by the service of rendering to us knives, arrows, or the like, have wardship of his heir of the land which he holds of another lord by knight's service. 38. No bailiff for the future shall, upon his own unsupported complaint, put any one to his law, without credible witnesses brought for this purpose. 39. No freeman shall be taken or imprisoned or disseised or exiled or in any way destroyed, nor will we go upon him nor send upon him, except by the lawful judgment of his peers or by the law of the land. 40. To no one will we sell, to no one will we refuse or delay right or justice. 41. All merchants shall have safe and secure exit from England, and entry to England, with the right to tarry there and to move about as well by land as by water, for buying and selling by the ancient and right customs, quit from a level tolls, except, in time of war, such merchants as are of the land at war with us. And if such are found in our land at the beginning of the war, they shall be dealt aind, without injury to their bodies or goods, until information be received by us, or by our chief justiciar, how the merchants of our land found in the land at war with us are treated, and if our men are safe there, the others shall be safe in our land. 42. It shall be lawful in future for any one, excepting always those imprisoned or outlawed in accordance with the law of the kingdom, and natives of any country at war with us, and merchants, who shall be treated as is above provided, to leave our kingdom and to return, safe and secure by land and water, except for a short period in time of war, on grounds of public policy reserving always the allegiance due to us. 43. If any one holding of some escheat, such as the honour of Wallingford, Nottingham, Boulogne, Lancaster, or of other escheats which are in our hands and our baronies, shall die, his heir shall give no other relief, and perform no other service to us than he would have done to the baron, if that barony had been in the baron's hand, and we shall hold it in the same manner in which the baron held it. 44. Men who dwell without the forest need not henceforth come before our justiciars of the forest upon a general summons, except those who are impleaded, or who have become sureties for any person or persons attached for forest offences. 45. We will appoint as justices, constables, sheriffs, or bailiffs only such as know the law of the realm and mean to observe it well. 46. All barons who have founded abbeys, concerning which they hold charters from the kings of England, or of which they have long continued possession, shall have the wardship of them, when vacant, as they ought to have. 47. All forests that have been made such in our time shall forthwith be disafforested, and a similar course shall be followed with regard to river banks that have been placed in defense by us in our time. 48. All evil customs connected with forests and warrens, foresters and warreners, sheriffs and their officers, river banks and their wardens, shall immediately be inquired into in each county by 12 sworn knights of the same county chosen by the honest men of the same county, and shall, within 40 days of the said inquest, be utterly abolished, so as never to be restored, provided always that we previously have intimation thereof, or our justiciar, if we should not be in England. 49. We will immediately restore all hostages and charters delivered to us by Englishmen, as sureties of the peace or of faithful service. 50. We will entirely remove from their bailiwicks, the relations of Gerard Athey, so that in future they shall have no bailiwick in England, namely, Engelard of Sagon, Peter, Guy, and Andrew of Chansos, Guy of Sagon, Geoffrey of Martigny with his brothers, Philip Mark with his brothers and his nephew Geoffrey, and the whole brood of the same. 51. As soon as peace is restored, we will banish from the kingdom all foreign-born knights, crossbowmen, sergeants, and mercenary soldiers, who have come with horses and arms to the kingdom's hurt. 52. If anyone has been dispossessed or removed by us, without the legal judgment of his peers, from his lands, castles, franchises, or from his right, we will immediately restore them to him, and if a dispute arise over this, then let it be decided by the 25 barons of whom mention is made below in the clause for securing the peace. Moreover, for all those possessions from which any one has, without the lawful judgment of his peers, been disseized or removed, by our father, King Henry, or by our brother, King Richard, and which we retain in our hand, or which are possessed by others, to whom we are bound to warrant them, we shall have respite until the usual term of crusaders, excepting those things about which a plea has been raised, or an inquest made by our order, before our taking of the cross, but as soon as we return from our expedition, or if perchance we desist from the expedition, we will immediately grant full justice therein. 53. We shall have, moreover, the same respite and in the same manner in rendering justice concerning the disafforestation or retention of those forests which Henry our father and Richard our brother afforested, and concerning wardship of lands which are of the fief of another, namely, such wardships as we have hitherto had by reason of a fief which any one held of us by knight's service, and concerning abbeys founded on other fiefs than our own, in which the lord of the fief claims to have right. And when we have returned, or if we desist from our expedition, we will immediately grant full justice to all who complain of such things. 54. No one shall be arrested or imprisoned upon the appeal of a woman, for the death of any other than her husband. 55. All fines made with us unjustly and against the law of the land, and all amercements imposed unjustly and against the law of the land, shall be entirely remitted, or else it shall be done concerning them according to the decision of the 25 barons of whom mention is made below in the clause for securing the peace, or according to the judgment of the majority of the same, along with the aforesaid Stephen, Archbishop of Canterbury, if he can be present, and such others as he may wish to bring with him for this purpose, and if he cannot be present the business shall nevertheless proceed without him, provided always that if any one or more of the aforesaid 25 barons are in a similar suit, they shall be removed as far as concerns this particular judgment, others being substituted in their places after having been selected by the rest of the same 25 for this purpose only, and after having been sworn. 56. If we have disseized or removed Welshmen from lands or liberties, or other things, without the legal judgment of their peers in England or in Wales, they shall be immediately restored to them, and if a dispute arise over this, then let it be decided in the marches by the judgment of their peers, for tenements in England according to the law of England, for tenements in Wales according to the law of Wales, and for tenements in the marches according to the law of the marches. Welshmen shall do the same to us and ours. 57. Further, for all those possessions from which any Welshman has, without the lawful judgment of his peers, been disseized or removed by King Henry our father or King Richard our brother, and which we retain in our hand, or which are possessed by others, to whom we are bound to warrant them, we shall have respite until the usual term of crusaders, excepting those things about which a plea has been raised or an inquest made by our order before we took the cross, but as soon as we return, or if perchance we desist from our expedition, we will immediately grant full justice in accordance with the laws of the Welsh and in relation to the foresaid regions. 58. We will immediately give up the son of Llywelyn and all the hostages of Wales, and the charters delivered to us as security for the peace. 59. We will do toward Alexander, King of Scots, concerning the return of his sisters and his hostages, and concerning his franchises, and his right, in the same manner as we shall do toward our other barons of England, unless it ought to be otherwise according to the charters which we hold from William his father, formerly King of Scots, and this shall be according to the judgment of his peers in our court. 60. Moreover, all these aforesaid customs and liberties, the observance of which we have granted in our kingdom as far as pertains to us toward our men, shall be observed by all of our kingdom, as well clergy as laymen, as far as pertains to them toward their men. 61. Since, moreover, for God and the amendment of our kingdom and for the better allaying of the quarrel that has arisen between us and our barons, we have granted all these concessions, desirous that they should enjoy them in complete and firm endurance forever, we give and grant to them the underwritten security, namely, that the barons choose 25 barons of the kingdom, whomsoever they will, who shall be bound with all their might, to observe and hold, and cause to be observed, the peace and liberties we have granted and confirmed to them by this our present charter, so that if we, or our justiciar, or our bailiffs or any one of our officers, shall in anything beat fault toward any one, or shall have broken any one of the articles of the peace or of this security, and the offence be notified to 4 barons of the foresaid 25, the said 4 barons shall repair to us, or our justiciar, if we are out of the realm, and, laying the transgression before us, petition to have that transgression redressed without delay. And if we shall not have corrected the transgression, or, in the event of our being out of the realm, if our justiciar shall not have corrected it, within 40 days, reckoning from the time it has been intimated to us, or to our justiciar, if we should be out of the realm, the 4 barons aforesaid shall refer that matter to the rest of the 25 barons, and those 25 barons shall, together with the community of the whole land, reign and distress us in all possible ways, namely, by seizing our castles, lands, possessions, and in any other way they can, until redress has been obtained as they deem fit, saving harmless our own person, and the persons of our queen and children, and when redress has been obtained, they shall resume their old relations toward us. And let whoever in the country desires it, swear to obey the orders of the said 25 barons for the execution of all the aforesaid matters, and along with them, to molest us to the utmost of his power, and we publicly and freely grant leave to every one who wishes to swear, and we shall never forbid any one to swear. All those, moreover, in the land who of themselves and of their own accord are unwilling to swear to the 25 to help them in constraining and molesting us, we shall by our command compel the same to swear to the effect aforesaid. And if any one of the 25 barons shall have died or departed from the land, or be incapacitated in any other manner which would prevent the foresaid provisions being carried out, those of the said 25 barons who are left shall choose another in his place according to their own judgment, and he shall be sworn in the same way as the others. Further, in all matters, the execution of which is entrusted to these 25 barons, if perchance these 25 are present, that which the majority of those present ordain or command shall be held as fixed and established, exactly as if the whole 25 had concurred in this, and the said 25 shall swear that they will faithfully observe all that is aforesaid, and cause it to be observed with all their might. And we shall procure nothing from any one, directly or indirectly, whereby any part of these concessions and liberties might be revoked or diminished, and if any such thing has been procured, let it be void and null, and we shall never use it personally or by another. 62. And all the ill will, hatreds, and bitterness that have arisen between us and our men, clergy, and lay, from the date of the quarrel, we have completely remitted and pardoned every one. Moreover, all trespasses occasioned by the said quarrel, from Easter in the 16th year of our reign till the restoration of peace, we have fully remitted to all, both clergy and laymen, and completely forgiven, as far as pertains to us. And, on this head, we have caused to be made for them letters testimonial patent of the Lord Stephen, Archbishop of Canterbury, of the Lord Henry, Archbishop of Dublin, of the bishops aforesaid, and of Master Pandulph as touching this security and the concessions aforesaid. 63. Wherefore it is our will, and we firmly enjoin, that the English Church be free, and that the men in our kingdom have and hold all the aforesaid liberties, rights, and concessions, well and peaceably, freely and quietly, fully and wholly, for themselves and their heirs, of us and our heirs, in all respects and in all places forever, as is aforesaid. An oath, moreover, has been taken, as well on our part as on the part of the barons, that all these conditions aforesaid shall be kept in good faith and without evil intent. Given under our hand the above named and many others being witnesses in the meadow which is called Runnymede, between Windsor and Staines, on the 15th day of June, in the 17th year of our reign. For more, don't forget to subscribe to our channel and turn on notifications, like the video and recommend it to your friends, and share your ideas and suggestions in the comments. Hoping for a more just world. Goodbye.